Hi everybody, this is Arkady Frekhtman. I'm a New York City personal injury trial attorney, and today I'm coming to you with a very recent verdict. And it was a truck crashing case, and it was a multi-million-dollar verdict. And I wanted to tell you about the case and discuss it because I really think it's noteworthy. Actually, recently in December and November of 2023, there have been a lot of million-dollar verdicts. And these include verdicts for 15, 16 million. There was one for 44 million. There was one for 105 million, 120 million. And there was even a verdict yesterday for $857 million. So there have been a lot of really big verdicts. And this is one of them. This is a truck crash that happened in the state of Georgia on a highway. And what happened was a truck driver was driving, and the plaintiff actually ended up hitting the tractor trailer, the trailer part, in the rear corner. And that was because the tractor trailer came to what it considered to be an emergency stop on the interstate highway. So the plaintiff had a tough burden. They had to overcome this issue of liability, and especially the general bias that, hey, if you rear end someone, then you're the one who's at fault. But listen to what happened. So this truck driver, it was a company that he worked for, and he was driving on a 5-lane highway that was an interstate. And he was in the second lane from the right. And as he approached the exit, a van changed lanes in front of him. And so this van is, heading towards the exit, and so it begins to brake. So when the van changes lanes, it's about 220 feet ahead of this truck, and it's a tractor with a trailer, okay? So then the trucker does not brake, right? He doesn't brake, he doesn't really even begin to slow down. Now, when this truck is about 180 feet from the van, and it's still not braking, the truck has something known as a forward collision avoidance system. And so the system engages, it's almost like cameras, and the cameras sense, hey, something's wrong, something's dangerous. So the cameras start to audibly warn the driver. So they tell the driver, hey, this is dangerous, you're getting too close. Then there's something known as haptic brakes. Now, haptic brakes, they vibrate. So the vibration is telling him, hey, something's wrong. He still doesn't brake, this truck driver. So then at this point, what happens is the trucking system, it ultimately engages the full emergency braking. So now the truck is braking on its own. And so the defendant in this case, what they argued was that the driver was braking, but that the forward collision system engaged anyway. So almost like the forward collision system wasn't working properly because the driver did brake. That was their argument. But so when this truck was going 27 miles per hour, this van that's in front of him, right, the van, all of a sudden this van leaves that lane. So now the van is out of that lane, and the van is going towards the exit. So the van is no longer a hazard. So at this point, this truck still doesn't, at this point, this truck just continues to brake because this system began braking, right? This forward collision warning system began braking, forward collision avoidance system engaged. And so the truck driver at this point, now the truck is braking, but there's no reason to brake anymore because the van is gone. The van took the exit. So now this trucker is just continuing to brake. All he has to do is disengage this system, but he doesn't disengage it, so he's just continuing to brake. So then at that point, what happens is traffic behind this truck, including another tractor trailer, they all start swerving to avoid this truck that's stopping for no reason. And so the plaintiff was 2 vehicles behind the truck. There was a Kia that the plaintiff was following, and the Kia swerved left. Then the truck between the Kia and the truck that was braking, that was stopping, also swerved left. So then the plaintiff could not see the stopped truck until the truck ahead of him swerved out of the way. And at that point, he tried to swerve to the right. Now we're talking about the plaintiff. He tried to swerve to the right to avoid it, but he clipped the rear corner of the trailer on this truck that was stopping. It already was stopped. And then he was hit by another truck that was in the right lane behind him. So basically, I watched a little bit of this trial. I watched some of the opening statements and I watched some of the closing arguments. I didn't watch the entire trial. It was on CVN, the Courtroom View Network. And I saw in the opening statement, the plaintiff's attorney, he did something known as the teaching section, where he explained that the jurors, in order to do their jobs, they're going to have to learn something about the CDL manual and about how trucks operate and about safety. So he talked about this 7-second rule, right? That a truck driver has to maintain 7 seconds or 600 feet of distance, and he can't follow too closely because a truck, a tractor trailer, takes time to stop. He talked about being proactive, and as a truck driver, when you're driving, you get to an exit, you have to be looking for other cars because people, other cars may be exiting, and if they are exiting, then you have to be careful. So you have to be proactive in that sense. And a truck should not stop if there's no traffic ahead. There's no reason to just stop on a highway. You can't do that. You have to know the technology in your truck and how to use it, how to engage or disengage, especially something like that automatic braking system. And you shouldn't really stop, or you should really maintain a minimum speed. Like a lot of people, and especially this was in Georgia, so a lot of people are going like 70, 80. This is a 5-lane interstate. Now, you could go slower, but at least you have to go 40. So there are certain minimums as well. So it was interesting because the plaintiff argued that the trucker did not brake properly, that this forward collision avoidance system engaged because he did not brake properly. And had he started to brake, then the system would have never engaged and the crash would have never happened. So that was the plaintiff's argument. And then the defendant just kind of said that, so then the truck would have never come to a stop at all. And the plaintiff also argued that the truck driver either didn't know how to disengage the emergency brake, which was a training issue, or he didn't follow his training. Like he was trained on it, but he just chose not to follow it. And then the plaintiff also got a corporate representative deposition from the trucking company. And the corporate representative, which is the voice of the company, they testified that it would be indefensible if the truck driver did not know how to disengage the emergency braking. So the plaintiff was able to prove that the truck driver hit the accelerator just a little, maybe like, 15 to 20% for a second, right before the time that van moved out of the way. Right before the van moved out of the way. So he wasn't braking and he was actually hitting the accelerator, even though the van was braking in front of him. I guess the van was looking for the exit, which it ended up taking without any collision. So this helped them defeat the sudden emergency argument because the defendant said, hey, this is a sudden emergency. There's nothing we could have done. So this helped the plaintiff defeat that. So the damages in the case. Now the damages, the plaintiff suffered a severe arm injury that permanently deformed his arm, prevented him from straightening his arm fully. He was only 21 years old. He was a student at a local college. Now, he also suffered a TBI symptoms. He was really out of it for a few months, but then he did make a miraculous recovery, but he still had some deficits, like the neuropsych testing showed mild deficits in executive function and processing speed. And this TBI, even though he was an exceptional student, he was exceptional in so many ways, but this did hurt him, and also what it did was it left him irritable, socially inappropriate. He was appearing aloof, unfriendly, uncaring, and even mean at sometimes. And he wouldn't know it. People would have to tell him. And then it kind of made him withdraw and not want to be around people, and also made him very self-conscious and awkward, and he lost his self-confidence. And this is like devastating for a 21-year-old man. So in the state where the case was tried in Georgia, the rule is that if a plaintiff is 50% responsible, he or she cannot recover at all, right? So you have to, and then the jurors were told that about the 50% rule. And so it was a strategic choice that the plaintiffs did not name the truck driver as a defendant. And so the judge allowed the defense to cross the truck driver in the plaintiff's case in chief, and then allowed the defense to question its corporate representative in its case in chief. So they asked the jury that the case was, actually they told the jury in opening statement that the case was worth $30 million, in closing as well. And they had $900,000 in medical records with no future specials at all. They tried to get futures, but they didn't get too many futures because the client recovered. And so they asked for a per diem argument broken down to hourly amounts for various aspects of damage that added up to just under $30 million. And for one of them, I watched in the closing argument, they only asked for $12 an hour, which is pretty fair. But, so the jury deliberated for 5 hours. They were out for only 5 hours, which is pretty short in a case like this. And they returned a verdict for $16,665,000. But they assigned the plaintiff 40% liability. That means that the plaintiff cannot recover for his share of the fault. He recovers 60% of $16.65 million, which is about $10 million, 9.99, I believe it is. And because they beat the offer of settlement by over 125%, they're entitled to fees and interest to be added to the judgment. And the case could have settled for $5 million, but the defendant's highest offer prior to this trial was only $2 million. And the plaintiff also asked for a high-low at trial, and that request was denied. So they probably asked for a low of maybe $2 million and a high of, I don't know if it was 5 or 6, to kind of protect him, that he would get the 2, he wouldn't get a defense verdict of 0. But then the high would be 5 or 6. That would protect the insurance company. They wouldn't have to pay more. But the insurance company said no, because I guess they were really banking on winning on liability, since the plaintiff is the one who rear-ended the stop truck. But since they lost, now they have to pay $10 million. So it was a really great job, very good lawyering. And actually, this is the same firm that one of our YouTube viewers had a case, and they called me about it, and I did a consultation. They called me at 347-566-9595. And after that consultation, this is the same firm that ended up handling that particular case, also near Atlanta, Georgia, and they ended up resolving that case for, I believe, over $2 million. So this is the same firm, and now they just had this verdict. I believe it was just December. I see the email that I received about this from one of the listservs that I'm on, the American Truck Accident Attorneys. This was from December 15th. So this is just last week. This is just a few days ago. So very exciting stuff. Okay, please like and subscribe to our channel. Let us know what videos you want to see. We are here for you. Our goal is helping serious injury victims and families. And thank you for watching. Okay, have a great day. Bye-bye.